Okay, let's call this meeting to order. Welcome everybody to the Property Standards Hearing Committee. My name is Tom Neal and I am the chair presiding over today's hearing in accordance with the Statutory Powers Procedures Act. Today's hearing is being held in person and electronically for all participants who registered to speak. Everyone present will be given an opportunity to comment on the applications being heard, but please focus your comments on the property standard orders in particular and direct your comments through me as the chair. As always, participants, staff, and committee members are to be treated with courtesy and respect. Before we begin today's agenda, I'd like to take the opportunity to recognize the traditional territories of which we are on. The land on which we gather today is the traditional territory of the Anishinaabe, Haudenosaunee, Attawandaronk, and Mississauga peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many Indigenous peoples made up of First Nation, Inuit, and Métis. The Dish with One Spoon Wampum Agreement should remind us of our responsibility to ensure the dish and the territories on which we live and work is never emptied and that we take care of the land and its inhabitants in a way that ensures its future sustainability. Today's meeting is being live streamed by the City of St. Catharines. Individuals and media may be audibly and or visually recorded during the hearing, and all electronic devices are to be in silent mode throughout the hearing, and no recording devices are permitted during the hearing as per Section 29 of the Statutory Procedures Act. By participating in the open public meeting today, you are consenting to your image, voice, and comments being recorded and posted online. At this time, I would like to introduce the remaining members of the committee: Vice Chair Brianna Nieto and Member Adam Selvig. Also from the City of St. Catharines, we have Secretary Treasurer Elaine Monroe, Assistant Secretary Treasurer Rosa Risi, Officer David McClellan, Officer Robert Davis, and Manager of Bylaw Enforcement Paul Trudeau. We also have the representatives for the two appeals on tonight's agenda. For 131 Rockwood Avenue, we have Jessica Travers of Lotus Paralegal, and for 282 and 285 Ontario Street, we have Patrick Maloney from Sullivan Mahoney. The Property Standards Committee is a decision-making committee appointed by Council and functions under the provisions of the Ontario Building Code Act and the Statutory Powers Procedures Act. We are also all volunteer members from the St. Catharines community. The committee hears appeals of property standards orders issued under the Building Code and the city's property standards bylaws. The property standards bylaw regulates items of safety and general upkeep of properties and buildings, and if an owner disagrees with the order or a portion of an order, they may appeal to this committee. This committee has the powers to do the following: confirm the order as written, modify the order, rescind an order, or extend the time period for complying with an order. Once all discussions are completed, the committee will begin deliberations and may make a decision. This decision will be mailed out and include a statement indicating the opportunity to appeal the decision to Superior Court. May I have a motion to approve today's agenda? Moved by Adam. May I have a motion to approve the minutes of the May 26th hearing and the May 28th hearing? Moved by Member Nieto. Do any of the committee members have any pecuniary or non-pecuniary interest in the hearing today? I do not, none noted. The first item on the agenda today deals with 282 and 285 Ontario Street, as there is a request for adjournment. Patrick Maloney, if you may, you're representing 282, 285, if you may come up to the podium here. Good evening. Please state your name and address for the record.
Good evening, Mr. Chair, members of the committee. My name is Patrick Maloney. I'm a partner with the Municipal Land Use Planning Group at Sullivan Mahoney. Address is 40 Queen Street, if you wish to take that down with me. Sorry? Okay.
The appellant and the representative for the owner of 282 and 285 Ontario Street have requested an adjournment. This meeting was scheduled in accordance with the Property Standards Committee approved rules of procedure. Section 102, subsection 3 of the rules provides that the Secretary Treasurer of the Property Standards Committee, on receipt of the appeal, shall establish a date for the appeal hearing before the Property Standards Committee, which shall be within 60 days of receiving the appeal. The scheduling of this meeting by the Secretary Treasurer satisfies the 60-day requirement in Section 102, subsection 3. For the record, the request for an adjournment is a request of the appellant. For what reasons do you require the adjournment, and what date do you propose this matter be heard?
I do have some submissions that I'd like to make to the committee, and if you'll accept them. We are asking for a deferral of the matter. I am appearing on behalf of the lender, Catharines Investment Partners, who did receive a copy of the order. There's a couple different reasons why we are asking for a deferral of the matter. The first thing relates to timing. In this particular case, there was an inspection that occurred on May 22nd, 2026, just over a month ago. Was a Friday. An order was issued on the same date and was served late in the day by email to a partner with Catharines, or a representative of Catharines Investments, but not posted on site until a few days later, or sent in the regular course until a couple days later. The compliance deadline was June 12th, only 3 weeks after the date of issuance. The order is substantive, no doubt about that, and it relates to very complicated aspects, including the remedy or compliance in terms of remedy of demolition, or to fix the buildings to bring it up to the standards suggested by the city. The order was appealed, and a hearing was scheduled for today. So from the date of inspection to the date of issuance of an order, all the way to today, it's been just over 1 month on a fairly complicated matter. In our experience dealing with this particular committee and in other municipalities to which we act for and against, we feel that the city has not provided a reasonable amount of time to allow our client to either, one, actually comply with the order, or two, review the order and the substance of the order and provide an informed response as part of this appeal. One might think that just extending the timeline for compliance might be the appropriate remedy. However, if that was the case, we would then lose our right to challenge aspects of the order should that be the case. We were only able to do that once there is a more fulsome review by an engineering firm that will be undertaken by our client's engineer. So confirming the order and only granting an extension of time would mean that our client would not have its legislative right to make a valid case against this order, and would result potentially, as you indicated, Mr. Chair, an appeal to the Superior Court. That's not our intention, but that is a remedy that you indicated. The second reason is that there has been diligence already in responding to the order. Our client is not seeking time to begin compliance. Our client is already engaged in compliance and is seeking time to complete compliance in a technically appropriate way. Compliance requires an engineering assessment, permit determination, and safe execution of any repairs or demolition. So upon the receipt of these orders, our clients did contact their engineering firm immediately to address both orders. Unfortunately, due to the short time frame given, an assessment was not able to be done within a reasonable amount of time afforded by the orders. We do have an engineering group that has been retained, Kalos Engineering, that has been retained to address the order, and the site inspection has actually already occurred. In other words, Catharines has not sat on their hands and done nothing to respond to the orders. The third reason I'd like to say is that the site is secured. The property is continuously secured, actively monitored, and subject to ongoing remediation and maintained to mitigate current risk. It's secured in the form of fencing, and there is a regular patrols each day, I think approximately 6 per day, of a security firm that observes the property and ensures that nobody enters it. With that regard, safety of the property has been addressed to prevent trespassers. Now, we can't prevent every single person, but if you're a trespasser and you want to get into this property, you're going to have to make a very good effort to do that. The final comment I'll make is that this is not a request for an indefinite deferral, and we are not asking that the committee or the city not address the order or rescind the order in any way, nor is our client taking the position that nothing should be done. We are simply asking that a reasonable amount of time be given to us to allow our client to properly respond to the order and properly respond to the appeal that has been filed. And that is mostly as relating to the short time frame given to them. So the reason for the request is more of a deferral to allow our client's engineers to review the orders, determine compliance, what steps could be taken following that, and even potentially work with the city on how to address the order. So the substance of the order, as well as any decision of the committee, should be based on a fully informed and technical review of the requirements of the order, especially in this type of case. A decision of the committee should not be done on an impulse because of historical complaints related to the property. The order will have to be addressed one way or another. So we are simply asking for additional time to reasonably address the order and allow for us to properly respond to this appeal, particularly because of the extremely tight timeframe that was given by the city in the issuance of the order to today's hearing. So we are respectfully requesting that this committee defer the matter for a period of 2 months that would allow the engineer to complete his review. And I did speak with the engineer today about the timing of the full review and then timing that we'd be able to need to respond to the appeal and then be before this committee again and address the appeal in a more substantive and more technical matter. So subject to any questions you have, Mr. Chair or members of the committee, those are my submissions requesting a deferral for 2 months.
So to clarify, the request is for 60 days from today's date?
Yes, Mr. Chair. I know you are at the will or whenever you are set a date, so 60 days would be 2 months.
So my understanding was that the initial request for adjournment was due to a conflict of the traditional counsel of the applicant. But the reasons that I just heard were more or less a repackaging of the initial grounds for the original appeal. Can you comment on that versus the conflict that was identified?
Yeah, that's a good question, actually, because I think the original request for an adjournment was made by Solernus themselves. They were having issues in that regard, but they've since retained our firm, and that's why it's different. I was going to ask Ms. Monroe to change the agenda, but it had already been circulated, so I appreciate you actually asking that question. So it's no longer about retaining new counsel, it's more about the issues that I've raised here.
Do any representatives of the city wish to comment on anything just presented by the applicant?
Mr. Chair, I can. Paul Trudeau, the manager of bylaw enforcement and licensing for the city. So, I've heard what the appellant's representative has to say. I will present to the committee that the city's bylaw enforcement staff, the officers are present, our packages are here. We are fully prepared to have a hearing today. I'm more than willing to discuss all the terms and conditions. Having heard what the appellant's representative said about timelines for compliance, 1 month has well expired already since the initial order was issued. If these weren't things that were already in motion in terms of hiring engineers to review property to determine what to do with it, or it should have been done so prior to our attendance then. But if we're at the position that things are in motion, which is what we expect, what we want to happen is for a site to get remedied to conform with the minimum standard of our property standards bylaw. Timeline, we understand it wouldn't take, it can't be done overnight. There needs to be time to get this resolved. And that is agreeable, but it is not sure exactly what timelines are expected and how far we're looking at. In the end, we're looking to get our order confirmed as written. If it's modified for an extension of time to comply, that's acceptable, but there has to be a finite timeline as to when this would be resolved. And that's why I put it back to the chair, potentially for the appellant's representative. Is there a timeline which is reasonable that can be determined today to proceed, as opposed to another 2 months before we have to come back again to decide what is reasonable?
Would you like to respond to that?
Sure. I don't know if it's your regular procedure to do this, but the issue is that if you simply just give an extension of the time to comply with the order, then that doesn't allow us to properly respond to the substance of the order. And that's what Mr. Chidoba is asking us to do. But what I'm saying to you is, in order for us to have an actual review of the order and a substantive response to the order, we require a deferral for 2 months. And then after that, we can have a hearing as it really, and it's more informed hearing that this committee will be able to make a more substantive decision on, as opposed to just giving us more time to comply.
Does the city have any further follow-up or comments on the response?
Thank you, Mr. Chair, and thank you for the opportunity for the rebuttal on this as well. I do understand the position that it sounds like there's an uncertain timeline. However, there has to be a certain limit as to what exactly that could be. If that's the case, has the engineering company come forward and say, we require this 2 month and so forth to do the full assessment, or is this, we just need to put this off to gather people together, or that? I would imagine if an engineer has already attended the site, as we just heard today, then this should be in motion already, and if it's a priority, we should be able to get some type of results sooner than later. So a sooner timeline than 2 months for a reconvene would be understood within a reasonable timeline.
Do any committee members have any questions or clarifications they'd like to ask of the city's response or of the applicant in general? So the request for adjournment goes beyond the statutory date of August 9th. So does the appellant waive the 60-day time period to have this appeal heard by the committee with the request to adjourn to August 23rd, 2026?
Yeah, that would only be reasonable. And as I said, the 2 months, as I made it very clear, was that's at the behest or request of the engineering firm that's undertaking the review. So yeah, I would have no issue with waiving that requirement.
So at this point, I'm prepared to make a motion on the request for adjournment. Given the oral and written presentations that we've received, the compliance timeline is a statutory requirement by the Ontario Building Code. So I'm not satisfied that it's in the public interest to further adjourn this hearing, that we can't discuss it today. So I move to deny the adjournment and proceed with the hearing. All those in favor? Okay, so the request for adjournment has been denied, and we will proceed with that as item 2 on our agenda this evening. So we'll move on to the first application of the agenda. You can proceed back to the gallery, and we'll recall you later this evening. So the first application on tonight's agenda is with respect to 131 Rockwood Avenue. May I have the applicant step forward to the podium for that, if they are here? Please state your name and address for the record, please.
Emmanuel Junta at 131 Rockwood Avenue, Unit 59.
Thank you. Just switch back and forth with the mic. Our first appeal being heard today is to consider appeal reference number 60.82.303 made by Emmanuel Gunta, Maria Christina Gunta with Representative Jessica Travers regarding the decision of the Property Standards Officer to issue order number 26-103592MB with 5 items of contravention against the property municipally known as 131 Rockwood Avenue, Unit 59. The rules of evidence of the Property Standards Appeal Committee are informal. However, anyone giving evidence at this hearing as a witness must first affirm under oath to tell the truth. The way in which the hearing will proceed is as follows. First, the city representative will present their case explaining the investigation and why the order was made. Following that, the committee will have discussion and can ask questions of the city's representative. Thirdly, the owner or representative can ask the city's witnesses questions and the city can respond as needed. Fourth, the owner or representative in this case will present their side, including evidence and witnesses, followed by additional committee discussions of the appellant's case, followed by the city's opportunity to ask the appellant and their witnesses any questions, and the ability to respond, following by closing submissions if required by both the city and the appellant. All questions to witnesses, whether from the case presenter, the Property Standards Appeal Committee, or the appellant, must be related to matters that are relevant to the hearing. The Property Standards Appeal Committee may recall a witness for their presentation for the purpose of clarifying a point that has arisen since the witness has concluded their presentation. In addition, any person giving evidence may refuse to answer any question asked of them if the answer may tend to incriminate them or may tend to establish their liability in a civil proceeding. After hearing all the evidence and submissions, the hearing is completed and the Property Standards Appeal Committee will then make its decision. I would like to reiterate that we are here today to discuss the particulars of the property standards order in question, and the appellant is to set out specifically what the appeal is for. Who is the city representative that will provide an overview of the circumstances leading to the issuance of the order?
Mr. Chair, that'll be me, Paul Chidobin, Manager, Bylaw Enforcement and Licensing for the City of St. Catharines.
Okay, before doing so, I'll read you your oath of truth. Please raise your right hand. Do you affirm that the testimony you are about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do.
Okay.
Mr. Chair, I'd like to call upon Officer David McClellan for testimony.
Okay, you may proceed. Officer McClellan, will you please raise your right hand for the oath of truth? Do you affirm that the testimony you are about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do so.
You may proceed.
On March 26, 2026, I attended the property of 131 Rockwood Avenue, unit number 15, in response to a bylaw complaint. During that inspection, it was noted that the tenant or the occupants were without a kitchen. Photographic evidence was taken by myself to depict what is existing at the or within the unit based on the evidence that I obtained during that inspection. I found it reasonable and just to issue a property standards order to ensure that the owner does install a kitchen within the unit. This property standards order was sent to the owner via registered mail, and a copy was also emailed. On March 31st, 2026, I reattended the property to post the property standards order as per procedure. Those are essentially the facts in the case.
Do any members of the committee wish to clarify or ask questions of the city representative?
Yes. Some of the photos, I was a little confused on where it was. It looks like it's in a basement. Is that where the kitchen was? Or is that a basement that's just storing kitchen supplies, like a sink?
If there's appliances in the photographs that are depicted, I do have the photographs in front of me. I don't know what page you're on, but I could elaborate on them. Yeah.
Sorry, I'd have to go back and switch
For the
multiple
ease of the
files.
conversation, no, the kitchen is on the main level of the unit.
Okay.
Any other questions of the committee? Okay, I have none. Thank you. Okay. The appellant, yes.
I might have not spoken properly earlier, but I'm just requesting more time to get everything complete. That's it. That's pretty much the summary of the entire situation. It was, I don't know if you want more particulars than what he presented, but
Okay, yeah, we have a procedure to follow, but we'll get to that.
Okay, thank you.
So as the representative, you please raise your right hand for the oath of truth. Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed with your request.
Yes. There was a burst pipe in the home. It was supposed to be habited by somebody, and then upon arrival, we found out that the management company was there, came in, and they found the water leaking everywhere, and we took care of that, turned the water off, and it is an insurance claim. At this point, it has been since day one. So I'm just got some answers from the insurance company in the last few days. There's my personal insurance on the property. There's the condo insurance and also renter's insurance involved. The tenant did not have any renter's insurance. And I was just trying to get some answers and more time to get everything complete. I just received, like I said, word this week from the insurance companies on how it's going to work and what they've approved. And I'm just waiting for contractors to be available to come in and begin the work.
Did you have so the request is to confirm the order with an extension of compliance? Did you have a
Pardon?
date?
Sorry, I didn't.
The request is for confirming the order, but a request for extension of time for compliance. Did you have a timeline in mind?
I'm not sure how long the contractor would require for that. I know they are booked, if whatever the board would allow, 60 days, 40 days. The contractor's going to be informed to start as soon as possible, and however long it takes for them to fit into their schedule.
Okay. Do any members of the committee wish to respond or have any questions of the applicant?
The order was issued March 26th. When did the issue occur? Like was it?
February.
In February?
Yes.
So it's been 5 months, 4 or 5 months. Okay. And it's just been no communication between the insurance companies regarding this?
I've sent multiple emails multiple times, and they weren't able. The issue is there's 2 insurance agencies. There's a personal and condo board. This is my first experience of this nature. And the personal insurance covers a certain aspect of what's in the unit. Condo board covers the other aspect. There are items that they're still not fully agreed upon at this time, but they've finalized that there's going to be an invoice sent from the condo board. The particulars were it was a very horrible process, to be honest. And they've made some inroads now. We've had quotes for a while in terms of what needs to get taken care of. There was also some issues at times, various to get into the unit. There are at times people not there, and it was a very horrible insurance experience, to be honest. And I'm surprised it's taken this long. I don't want it to be taking this long. I got the quotes a while ago, and they've been waiting to let us know, for me to let them know when they can book it in and start.
Sorry, through the chair. In the meantime, because there's no kitchen, how has the tenant been eating? Eating, cooking?
From my
idea?
understanding, they should have had renter's insurance. I don't know how to answer that. I have no idea.
Like, have you been inside? Like, have you seen? Do they have like?
I've knocked on the door a few times, and they don't answer. I haven't seen them around very much. Others in the complex have said they've seen them around.
All right.
I'm not sure. There was a period when they weren't staying there. The tenant was not the again, I don't want to focus on the matter at hand, but there's other variables that I'm still unaware of to this point with the tenant.
Okay, thank you.
Based on the request for an extension of time, would Officer McClellan or Manager of Bylaw Enforcement wish to comment on the request?
Mr. Chair, I can. So in these types of circumstance, when we have, if the unit was unoccupied, if it was 6, 7, 8, 10 months, a year, that doesn't have an impact as opposed to a unit that is occupied with somebody living in there, especially when having no ability to perform basic cooking safely. 9 weeks has already passed since we issued the initial order. It is understood that insurance claims take time and they can be frustrating. There's no doubt there, and there is understanding there. But I do have to revert back to this also involves people. And because of that circumstance, things need to get expedited. Eventually, if an insurance claim comes through, the money goes into the bank eventually, but the repairs would still need to be done, and especially because there's someone involved. So because of that, 9 weeks have already elapsed. Doesn't appear that there's any commitment to having work already starting, swinging hammers, anything of that regard. It appears we're still at the obtaining quotations or trying to get a timeline for construction start date or even building permits, any of those things that should have at least already started to begun. And not being at that position after 9 weeks and not knowing exactly how much time we need, it's difficult to answer that question. However, I would expect an immediate start. How long does it take to restore a kitchen? I don't have an exact, I would expect that that would have come to the committee today as to when this construction will be completed by, so that way we can confirm an order based on some dates. That's all I have, Mr. Chair.
Okay, thank you. Is anyone in the gallery wishing to speak on this appeal today? None? Has anyone registered to speak for this?
Nobody has registered to speak.
Okay, in that case, we are at the point of closing submissions. Does the city wish to make any additional statements beyond what's already been discussed?
Mr. Chair, the only statement I have to make is that we are wishing to see this order confirmed as written.
Okay, as the appellant, you may make your closing submissions.
Yes, I'm fully want to get everything complete as quickly as possible, and I was not sure of how to proceed with the variables of these insurance agents, insurance companies, but I can start telling the contractor to start the work as quickly as possible. And I can get back to find out if they can give me an idea of time frame very quickly to the city and find out.
Okay, thank you. Microphone. Okay, at this point, does any member of the committee have a motion they'd like to bring forward regarding this matter?
Make the motion. Following all statements made by the appellant and the city, for notice of hearing 26103-592 MB, 60.82.303 for 131 Rockwood Avenue, Unit 59. I confirm the property standards order as written.
Thank you. So the motion is to confirm the order as written. All those in favor? Okay, the motion to confirm the order has passed unanimously. And it's been moved that items 1 to 5 of the property standards order 26103-592 MB for 131 Rockwood Avenue be confirmed. Secretary Treasurer, may you please read the decision?
We, the undersigned, duly appointed members of the Property Standards Committee of the Corporation of the City of St. Catharines, constituting a majority of the said committee, sitting on the 25th day of June 2026, to hear the appeal from Order 26103-592 MB of the Property Standards Officer dated the 26th day of March 2026, and having considered all the evidence filed and representations made, make the following decision: that in the opinion of the committee, the order meets the general intent and purpose of the Property Standards Bylaw and the city's official plan, and direct that items 1 to 5 be confirmed as written. In accordance with the Building Code Act, the municipality in which the property is situated, or any owner, occupant, or person affected by the decision of the Property Standards Committee may appeal to the Superior Court of Justice by notifying the clerk of the municipality in writing and by applying to the court within 14 days after a copy of the decision has been sent.
Okay, thank you.
Sorry, if I may, is there an extension of time? What's?
So the motion has been to confirm the order as written, so
Yes.
there's no extension of time granted.
Okay, so when does, just to start as soon as possible, or how?
Can you comment on that? So it's the initial
just-
the initial compliance date from the initial order is technically the compliance date. So the order as written is what has been confirmed, the original property standards order.
When was that date? It's why we were in, I was just requesting for more time to get everything. Again, I apologize, my attorney, my representative is not here today. I apologize for the.
So what that means is that we'll be sending out a notice of decision. If you want to work with the officer on getting the work done, you can contact Mr. McClellan, And then the decision will outline the appeal rights as well to the statutory powers, but in the meantime, you can start, if you're not appealing, you can work with the bylaw officer.
I can work
with them to.
okay,
yeah.
my apologies.
Is that correct, or should I'll have the officer or Mr. Chidoba respond?
Thank you, and I could speak procedurally to this matter. So as the order is confirmed as of the date that was issued, I would mean to start work right away. Typically, when we get building permits, things are in motion, that's when the officer starts documenting, making sure that things don't stall, that we're still moving along.
Okay.
And getting that process done as quickly as possible is really what's important here, because time is of the essence now. As it's confirmed, it's now final and binding. Granted an appeal to Superior Court, of course, within that timeline. So, but yes, best interest, get things going, and the officer will guide you
So
as
I'll
well.
get things going, and then I'll speak with the officer in the city, and then we move from there.
That's correct, Mr. Junta.
Thank you.
Okay, thank you. Our next appeal being heard today is consider appeal number 60.82.307 made by 282 Ontario Street and appeal reference number 60.82.308 made by 285 Ontario Street with Representative Patrick Maloney of Sullivan Mahoney regarding the decision of the Property Standards Officer to issue orders number 26-106611 MB with three items of contravention against the property municipally known as 282 Ontario Street, and regarding the decision of the Property Standards Officer to issue order number 26-106552 MB with 7 items of contravention against the property municipally known as 285 Ontario Street. The rules of evidence, again, of the Property Standards Appeal Committee are informal. However, anyone giving evidence at this hearing as a witness must first affirm under oath to tell the truth. Just for the record, can you state your name and address again?
Sure, it's Patrick Maloney, a partner with the law firm of Sullivan Manny, 40 Queen Street here in St. Catharines.
Okay, thank you. So the way in which the hearing will proceed is again as follows. The city will present their case, followed by committee discussion, followed by questions for the city, followed by the appellant's case, followed again by committee questions, followed again by questions for the applicants, and then closing submissions. All questions to witnesses, whether from the case presenter, the Property Standards Appeal Committee, or the appellant, must be related to matters that are relevant to the hearing. The Property Standards Appeal Committee may recall a witness for the purpose of clarifying a point that has arisen since the witness has concluded their main presentation, and in addition, any person giving evidence may refuse to answer any question asked of them if the answer may tend to incriminate them or may tend to establish liability in a civil proceeding. After hearing all the evidence and submissions, the hearing is complete and the Property Standards Appeal Committee will make a decision. I'd like to reiterate that we are here today to discuss the particulars of the property standards order in question and that the appellant is to set out specifically what the appeal is for. Who is the city representative for this?
Mr. Chair, that's me, Paul Chidoba, Manager, Bylaw Enforcement Licensing, City of St. Catharines.
Okay. Before doing so, I will read your oath of truth. Please raise your right hand. Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Mr. Chair, I'd like to call upon Officer Robert Davis to provide testimony.
Officer Davis, will you please raise your right hand? Do you affirm that testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do, Mr. Chairperson.
Thank you. You may proceed.
Thank you. On May 22nd, 2026, I attended the property. We're going to do 282 first, sorry.
Yes, we can start with 282.
Okay. I attended the property at 282 Ontario Street in St. Catharines, responding to a complaint. I was met there by representatives of the property who were informed of the purpose of the inspection as well as our authority under the Ontario Building Code Act. Those representatives unlocked the gates to the property and I entered the property and started to inspect both the interior and exterior portions of the property. taking photographs as documented evidence. During that inspection, I revealed significant deficiencies. Some of those included collapsed and deteriorated roof sections, exposed building interiors to the elements, extensive corrosion and deterioration of steel structures, framing, roof trusses, damaged and missing exterior wall assemblies and cladding systems.
Sorry, there's no recording or photos allowed to be taken. You may continue.
Sorry. Accumulations of debris throughout the property, cracking, displacement, and structural damage to masonry, block walls, and unsecured
Sorry,
openings.
Officer Davis, can you speak a little closer to the microphone? I think
sorry.
it's hard to hear.
I'll start there again. Structural damage to masonry and block walls, unsecured openings permitting unauthorized access, partially collapsed and unusable interior structural components, failed roof decking and overhead structural assemblies, loose and hanging mechanical lighting, electrical components, and widespread prolonged water penetration and weather-related deterioration. Following the inspection, I went back to City Hall, reviewed my photos, and prepared the property standards order. A copy of that order was sent to the property management company Solernus later that afternoon, and then on the following Monday, May 25th, I posted the order on the property.
Thank you. Do any members of the committee wish to ask any questions of Officer Davis? Does the appellant wish to ask any questions of Officer Davis?
Just a few, Mr. Chair, if I may. Mr. Davis, so you were the person that undertook the inspection. What time did the inspection occur in the day?
The inspection at 282 started at approximately 11:54 in the morning.
Okay, and sorry, when did it end then?
It took us probably about an hour.
Okay. And then in relation to the timing for compliance, did you have any discussions internally about the 3 weeks that were granted?
No, that's just part of our standard operating procedure.
So you typically give 3 weeks to anybody who receives an order such as this?
Yes, sir, property standards orders, we give the 21 days.
Okay. And are there ever circumstances where it's maybe a little more complicated than other than putting a kitchen in a basement where you might require a little bit more time to get for reasonable compliance?
Yes, sir, this would be one of those cases where the work's gonna be a lot more extensive than, say, fixing an eaves trough or such.
Right, and in those cases, would you not agree that it would warrant a little bit more time than 3 weeks?
It's just standard operating procedure to put in the 21-day time frame.
Okay, so I understand it's more about standard operating procedures as opposed to a real review of the time that it would actually take to come into compliance with the order?
Yes, I just followed the standard operating procedure.
Okay, thank you. And would you agree with me that in order to obtain a building permit for a demolition, that it, in terms of preparing the application, undertaking all the necessary reviews, such as what the material might be within the building, typically takes a little bit longer than 21 days in order to get that permit?
I believe a permit for that's obtained in 10 days, legislatively, I believe.
Legislatively, but is it actually issued within 10 days?
To my knowledge, it is, sir.
And then you would agree with me that you would actually need time to actually undertake the demolition?
Yes, sir.
Now, I get the standard operating procedures, but do you think compliance with this particular order is reasonable within 3 weeks?
I don't know if I can comment on being reasonable, but if the property owner did start work, I could definitely book multiple compliance inspections as long as work was progressing and extend the time that way, I don't have the power to officially extend the order.
Okay, but would you extend the time in the order or just extend the time for compliance? Just say, hey, you got another week, or you got another 3 weeks, we won't charge you.
As the officer, the Building Code Act doesn't give me the power to extend the order officially. That's the committee or the next appeal, but I can book multiple compliance inspections to give the owner more time to come into compliance.
Okay. Those are all my questions, Mr. Chair.
Thank you. If there's anything else of the committee or the appellant, you may step down.
You want to do that?
Oh, yes. So that concludes the discussion for 282. We can proceed then with your testimony for 285 Ontario Street.
Sure, thank you, Mr. Chair. So on May 22nd at approximately 10:30 a.m., I attended the property at 285 Ontario Street to conduct a property standards inspection related to a complaint we had received. When I arrived at the property, I was greeted by two representatives of the property who were given an explanation of the complaint and the reasoning why we were conducting the inspection, as well as our authority under the Ontario Building Code Act. During the inspection of the property, it revealed extensive deficiencies of the bylaw. Some of those would be deterioration of exterior masonry walls, missing displaced and crumbling brickwork, multiple unsecured openings and broken windows permitting unauthorized entry, significant corrosion and deterioration of structural steel members, stair assemblies, concrete beams, slabs and columns, a partially collapsed parapet and wall section, collapsed and damaged interior ceilings, loose and hanging electrical, mechanical, and structural components, as well as extensive debris and construction waste throughout the site, as well as evidence of prolonged water penetration and weather-related deterioration. Following the on-site inspection, I reviewed the photos back at City Hall and prepared the property standards order, a copy of which was later emailed to the property management company. And then following Monday, May 25th, I posted the order on the property.
Okay, thank you. Do any members of the committee wish to ask anything of Officer Davis based on that testimony? None. Does the appellant wish to ask any questions of Officer Davis based on that testimony? And then just want to, as a reminder, try to direct their questions through me and I can direct them as required.
Sorry, through you, Mr. Chair. Similar questions. The 3 weeks you granted for this particular address is just your standard operating procedure. Is that what is that what you said in the earlier?
Through you, Mr. Chair, yes, sir. Standard operating procedure.
Great. And sorry, one other question I did have. When you approached the property, you had to be let into the property, like you weren't able to access the property without getting access through the representatives?
Through you, Mr. Chair, that was a courtesy to the property owner. We do have the authority under the Building Code Act to enter the property. Yep. So it was a courtesy with the property owner. Right,
but you break the lock yourself if you had to. But I mean, you didn't have the opportunity to just walk in without having to do something to get yourself into the property.
Through you, Mr. Chair, no, both properties had locked gates, so we allowed the security to open it up for us.
Those are all my questions, Mr. Chair.
Okay, if there's nothing else, then Officer Davis, you may step down.
Sorry, Chair. I just occurred a question. I apologize.
Sure.
Have there been any other property standards orders issued against the property?
Currently, so for 285, there are 2 other outstanding orders, and for 282, there is 1 other outstanding order.
Okay. Do you know, top of your head, when those orders were issued?
The one order was issued possibly a week or so before, the other about a day or 2 before.
Okay, thank you.
Okay, Patrick Maloney, will you please raise your right hand for the oath of truth? Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do, so far as making any submissions, yes.
Okay, you may now present your appeal in your case. Sorry, can you put your microphone on?
So going back, similar to the same theme as what you heard earlier in terms of requesting a deferral, is at this point we do not have a structural engineer report prepared. As I indicated, insufficient time was given from the date of issuance of the order on a Friday to today's date of the hearing, just over 1 month. So substantively, I am at a loss because I cannot respond to any of the items within the order. However, if it pleases the committee, we would be seeking an extension in terms of compliance with the order for a period of 120 days. As I indicated earlier, we've communicated with our engineer, notwithstanding what might have been said earlier, who said it would take them approximately 90 days, or 60 days, excuse me, to obtain that review. And as I said earlier, this is not an uncomplicated matter. This is not a situation where it's a fridge or an appliance within a basement. This is a really complicated matter, which if there was a demolition permit that needed to be issued, there needs to be reports, there needs to be structural assessments, there need to be application, and that's just pre-application process. And then there's a process undertaken by the city, including a review of the building permit. 21 days is clearly insufficient and in a lot of ways patently unfair to the owner. So while I respect the fact that the city needs and wants the property to be remedied as it relates to the property standards bylaw, it cannot be done on a whim. It cannot be done in a vacuum as what we're currently faced with right now. So if it pleases the committee, we are looking for an extension of compliance of the order for a period of 120 days.
Do any members of the committee wish to respond or ask questions of the appellant?
I have a question. As this is a complicated property, just for clarification, so to me, I couldn't figure it out in documents provided. When did the current owners take ownership of the property?
Through you, Mr. Chair, I'm acting on behalf of the lender of the property, so it's the owner of the property I don't think has changed, but it's the lender that's activated at this point. We're not a mortgagee in possession, we're just a lender.
Yeah, I just had some things I wanted to address with the grounds for the appeal. There was some reference to the timelines with respect to compliance. Manager Tudoba, can you comment on that? So my understanding is that the timeline to compliance is set up by the building code. I know it was referenced as standard operating procedure, but that's a building code statutory requirement for compliance?
Through you to you, Mr. Chair, that is correct. The Building Code Act stipulates 14 days for compliance. If personal service is not affected, that adds an additional 5 days, so minimum of 19 days requirement according to provincial statute. The additional 2 days are added.
Okay. Question for the appellant. There was another note in the grounds for the appeal that the orders may benefit from clarification and or modification to reflect actual site conditions. Is that the engineering report that you're referring to?
Sorry, Mr. Chair. I was just looking at the legislative requirement. I think my friend Mr. Chidowa was talking about in terms of service. I don't know. I think a municipality can extend a time frame as it wishes, but sorry, the issue is obtaining an engineering opinion as it relates to the condition of the building and in response to the order that was issued by the city. Yes, that is absolutely what is necessary. It would be necessary even if they wanted to comply within the 21 days, which they wouldn't be able to do because that's just too short of a time frame to do that.
Okay, I'd just like to circle back to the comment about the city being able to extend that. Can the city comment on that?
To you, Mr. Chair, the Ontario Building Code Act also allows for prosecutions up to a period of 1 year, and that's in excess of a standard Provincial Offences Act statutory period of 6 months. Reason being for that year is it's understood that these are more complicated matters under the building code and they take more time. That's why that's provided for in there. But as the officer provided in testimony, they do not have the authority to, under the Building Code Act, to extend timelines for compliance. However, they do delay their inspection based on instructions from the property owner. So an offense does not begin as soon as the order is issued. It's after the order is confirmed, and then when the officer inspects and finds a violation still exists, that's when the 1 year clock starts ticking.
Is there anything you wish to respond to that?
Yeah, if we're going to talk about charges under the Provincial Offences Act, then yes, the first day that it's not complied with, so the 22nd day, the city is within its rights to enforce and to lay charges on it. So it's not as simple as just saying, oh, we may or may not do anything. The city could do it immediately. And that's the point, is we're trying to remove that ability so we can actually take the steps in order to comply with the order.
So we've had some hearings similar to that effect. So for more complicated matters like that where there's permits required and it's clear that a more longer time frame is reasonable, what's the city's mechanisms given those in order to, as long as work is considering to be progressing? Obviously, if an order was confirmed today, it would technically be non-compliant. since I believe the order to comply was prior to today's date. But recognizing the fact that more complicated issues require more time and permits, what's the city's general position on allowing that to proceed if an extension is not granted?
So to you, Mr. Chair, well, for the first part, this is typically the forum that we would explore if a property owner was looking for an additional extension of time, so that way they could bring it forth to the committee and we would go with that. Subsequently, if a order is confirmed within that specific timeline, then we would continue to monitor progress. If the property owner obtained a building permit for construction or demolition, that would be progress. If matters would start to stall, then that's when enhanced enforcement would potentially occur. But ultimately, most circumstances are unique, and that's why we document all interactions and actions we take.
Okay, thank you. So to circle back to my question, I believe you confirmed that one of the grounds for appeal was benefit of clarification and modifications to site conditions, which is the engineering report that you referred to?
That's correct, Mr. Chair.
All right, so as an engineer myself, I can appreciate that, but my understanding, so there's a few orders with respect to structural condition. My understanding, and this question is for the city, is that if an engineering report comes back and says that a structure is sound, that would be compliance with an order? Or that could be used as compliance for an order as opposed to demolition?
Through the chair, it could, if the intent of the property owner was to fully restore a property, then that would be part of it, yes.
Okay, thank you. There was also a note about some coordination with the Ministry of Environment, Conservation and Parks. Can you comment on what that work is?
Yes, Your Worship. There's ongoing Your Worship, excuse me, Mr. Chair, different court form. There's ongoing remediation with the property. So even there's an expectation that there may be materials within the buildings that if there was a demolition permit that would need to be addressed. So I think that's what that's referring to.
Does the city or the committee have anything further they'd like to ask or add?
Mr. Chair, I do. I just wanted to confirm with the appellant's representative an extension of time for 120 days. Can I get that confirmed?
And can you confirm that?
That's what I asked for.
Okay, yes, so the request is for 120 days from today's date or from the order date? Sorry? From today's date?
I'm going to suggest today's date because the engineer has been activated, and so he does need to undertake his report.
Okay, is there anyone from the public present that would like to speak today? Okay, I'll start with the first row there if you want to come up to the podium. Any of the two in the front of the podium there works, yeah. And then the microphone, just a button on the bottom right, and then state your name and address for the record.
Anne-Marie Zamet, and I am a resident of St. Catharines.
Okay, may you please raise your right hand for the oath of truth?
Sorry?
Can you please raise your right hand for the oath of
Yes.
truth? Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you may proceed.
Thank you. Good evening. Thank you for the opportunity to address the committee. I am asking the committee to deny the request for appeal. I am of the opinion this is a tactic to simply stall what is going to be a very expensive cleanup of the subject properties. In case anyone has forgotten, the property was purchased in 2014 and over the subsequent 12 years has not been maintained. I am of the opinion the owner knew or ought to have reasonably known what they were getting into when purchasing lands on which industrial manufacturing has been carried out for over a century. They assumed the risk, and with that, the responsibility to maintain the property as per property standards bylaw. All property owners are subject to this bylaw, regardless of zoning, complexity, or the history of the property. There is irrefutable photographic evidence that the buildings on the property are literally falling apart. The bylaw officer correctly applied the standards and issued a fix or demolish order. Given these facts, the request for appeal falls apart, as there was no error in the application of the bylaw. But let's get to what this is really about. It has been recently reported and proven by an independent laboratory that the soil on the subject properties is contaminated with asbestos, the origin of which is from the buildings in which asbestos was used during manufacturing process. This, of course, will require additional time, labor, and expense to ensure the contaminant is properly contained and removed prior to any fixing or demolishing of the buildings. That is not the committee's problem, that is not the municipality's problem, and that is certainly not the problem of the citizens who live adjacent to the subject property. The responsibility lies squarely on the owner. Again, when they purchased the property in 2014, they knew or ought to have reasonably known what they were purchasing. If this is a case that the previous owner had misled or did not disclose the true nature of the property prior to its sale, the current owner has had the last 12 years to sort that out. However, no evidence has been made public that there is any dispute between the current and former owners about the state in which the property was sold. In fact, both parties have made claims that everything about the property has always been above board within ministry guidelines, that everything is fine and safe. We know that is not the case, and the owner must be directed to bring the property up to standards. Judging by the turnout this evening, the public expects nothing less from this committee. The time is now. No more delays, no more inaction, no more excuses. We have seen the enforcement of orders on the senior citizen whose lawn has overgrown because they are no longer physically able to push the lawnmower. If they receive no leniency for their transgression, certainly the owner of the subject lands must be held to the same standards. Please deny this appeal and enforce the properly applied orders to fix or demolish the buildings on the subject lands. Thank you.
Thank you. Does anyone from the committee wish or have any questions they do wish to ask of the presenter? None? Does the city have any questions or comments they'd like to add to the presenter?
No, Mr. Chair.
Would you like to comment on anything? Okay.
Thank you.
You may head back to the gallery. Is there anyone else from the public that would like to speak? You may come up in the front row. We'll start there. So as before, please state your name and address for the record, please.
My name is Sabrina Hill, and I'm a resident of the city of St. Catharines.
Okay, please raise your right hand. Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I so affirm.
Okay, you may proceed.
Through you, Chair, hello members of the committee. When I wrote this, I did not know whether the owners before you today intended to appeal this order or whether they intended to seek yet another extension. In many respects, however, that distinction is irrelevant. The fundamental facts remain unchanged. The current owners have had more than a decade to meaningfully manage, remediate, and develop this site, and they have failed to do so. Over that same period, contaminants have continued to leach into the surrounding environment. Nearby waterways remain at risk. Soil contamination remains a concern. Residents now face the additional prospect of asbestos in the soil, a material that can become airborne and spread beyond the property's boundaries. I have toured this site extensively by air legally, including as recently as July 21st. I have provided the committee with photographic evidence. I don't know if you were able to. I'll continue while they're sorting that out. During a recent phone call with a concerned resident struggling to find the words to describe what remains there, the closest we could come to when characterizing the conditions of the property was that it was an end-of-days set piece straight out of Fallujah in the early days of Operation Phantom Fury. What exists on both the east and west side of the property, or Ontario Street, can only be described as a surreal, post-apocalyptic hellscape. A scene that feels less like an industrial property awaiting development and more like something from a William Blake fever dream. Littered across the site are vast quantities of broken glass, tetanus-topped rebar, dangling electric wire, deep auburn pools of stagnant diesel, and mossy-colored quagmires of nauseous chemicals. Standing water collects throughout the property, slowly seeping into the subterranean oubliettes at the foundation. All the while, wildlife continues to drink and bathe in it. For years, residents have been told that the property is safe and secure. My observations suggest otherwise. Fencing and gates are in serious disrepair, only being occasionally repaired. I have personally witnessed substantial deadfalls on both sides of the property, some only being walled off on 3 out of 4 sides. There's one right there, in fact. Areas that once contained underground infrastructure, piping, and industrial systems have deteriorated into flooded voids that continue to undermine already failing foundations. For more than a decade, this community has watched the 4 horsemen draw even closer to this property, not because the dangers are unknown, but because decisive action has perpetually remained over the horizon. The biblical book of Revelation speaks of the 4 horsemen of the apocalypse: conquest, war, famine, and death. Conquest, because delay has become strategy. War, because residents have spent years battling simply to have obvious dangers acknowledged. Famine, because this community has been starved of accountability and meaningful action. And death, because every year that passes increases the risk posed to the environment, the wildlife, and the public. The arduous march through the city's labyrinth process to get us from this point has often felt like an exercise in logic designed by M.C. Escher himself. Yet despite the delays, the studies, the reports, the hearings, and the promises, the site remains in a condition that no reasonable person could describe as acceptable. If an appeal is being requested, I urge the committee to uphold the order. If an extension is being sought, it should not be open-ended. It should be tied to strict benchmarks, firm deadlines, publicly reported progress, and meaningful enforcement mechanisms, and those should those benchmarks not be met. I would also ask this committee to reflect on a simple question of fairness. Ordinary homeowners in this city are expected to comply with property standard orders. They do not receive unlimited time. They do not receive endless second chances. Not to plagiarize the previous speaker, this was a complete coincidence. A 70-year-old widow can find herself facing enforcement action over a disquieted dandelion-filled front yard. Yet the owners of this property, or their lenders, have been afforded more than a decade to address the conditions that pose demonstrable and existential risks to the environment and the community, and the bylaw officers that have to service this area. Whether that perception is fair or not, many residents have come to believe that one set of rules applies to ordinary citizens and another applies to well-resourced corporate property owners with close personal ties to some elected officials. Public confidence in municipal enforcement depends on demonstrating that the same standards apply to everyone. After more than a decade, the time for explanations has passed. The time for action is now. Thank you.
Do any members of the committee have any comments or questions they'd like to ask the presenter? Does the city have any comments or questions they'd like to ask the presenter?
No, Mr. Chair, thank you.
None? Okay. You may head back to the gallery. Are there any other members of the public that wish to speak? Start up in the second row there. Yourself, sir, yeah. Please hit your microphone and state your name and address for the record and raise your right hand.
My name is Phil Baranowski, and I live in the city of St. Catharines. Can you hear me?
Yes.
Oh, okay. All right.
Sorry, can you state your name and address again?
Oh, it's Phil Baranowski, and I live at 18 Kilkenny Drive in the city of St. Catharines.
Okay, and I have to swear you in. Can you please
Just,
raise?
yeah. Okay, Tom, I want to...
Please raise your right hand first. I have to swear
sorry.
you in.
I swear.
Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
Yes, Tom.
All right, thank you. You may proceed.
Okay, just to bring you up to date, okay. I used to be on this committee for 19 years. Elaine knows that, okay. And I've got a few questions I've got concerns about. Okay, I'm 80 years old, okay. I used to work in around 1965. I was at the GM plant in that building that's very rough shape. I find it very upsetting. And Sabrina did some excellent talks on it. I also have a degree, I've got a banker's degree, but I've got a degree in urban environmental studies, and I find this very disgusting. Every time I drive by the place, it is upsetting, and especially when you worked in there. And I think there's stuff about asbestos, but I've also worked at the Black Box at GM on Glendale Avenue, and that was torn down because of the asbestos. That was General Motors. But the one thing I want to bring up about that has really bothered me since this has started was the fact is this property was bought, and as far as I know, I haven't looked at the registry records, 2014. I was on the committee where we see, that used to be my seat, and the other people, we never did anything up the top. It was all done locally. Anyway, what I'm concerned about was that this has been really bothering me. Why has there been no other complaints filed till now? Like, why? There should have been. That building has been deteriorating and nothing's written. Like, has there ever been a complaint filed till, it just seems like this year it just started. Is it because it's an election year? What? And the other thing that's really strange, okay, is they've changed some of the process. You had to have a written complaint form, and it was kept confidential. And now you could phone. And an example of, like Sabrina was saying, about people being, having problems with property standards and the bylaw officers. My daughter, shed, she received a bylaw complaint, the whole thing, and it was because of a downspout that was going incorrectly. It had to be moved 45 degrees just to turn it, to get it corrected. And the cost involved and was unreal. And it was a neighbor phoning in on the issue, which was a waste of time. How I know? I'm on Title II, so I got copies of these registered letters and the complaints. But what my concern is, something has to be done. And as far as I'm concerned, there should be a demolition of this property. I'm concerned about the environmental issues. They're worse now than they were before because of the deterioration of the meeting. And the bylaw officer, you did a great job, but there had to be something wrong with the building, we'll say around 2016. I mean, if you're worried about a downspout on a house, that building was starting to deteriorate.
So I heard.
by then.
Sorry.
So I'm.
No, I don't. I just wanted to address, it sounded like you had a question about prior complaints and orders, so I just wanted to throw that to the city. Can you comment on if there have been prior orders and complaints against this property?
That's what I want to know.
Okay, so through the chair, in this, for respect to the properties 282 Ontario Street and 285 Ontario Street in regards to the structure in the building, no formal record of complaint.
There has that been none? Technically, after I've been off the committee, while we're on the committee, you realize you can't file a complaint, okay? I'm just bringing you up to date, okay? But I could have done that very easily. Or anybody on the street just said, I cannot believe there hasn't been a complaint. That's what I find very difficult. And that's just what's bothered me, okay? I know you're doing your job, Tom, Brianna, and Adam, and this is a very difficult case. I understand it. And the odd time, we used to have a lawyer that sat here representing, but you know how complicated it is. So, but anyway, I just want to say, you have not received a complaint in the files? I mean, I'm talking back to 2014.
So I believe I heard the city state that there's no record of a formal complaint. That's the question. Is that what the city's position?
There are no phone calls? No nothing? That's very unusual.
We'll just let the city respond.
Mr. Chair, just for clarity, with respect to 282 Ontario Street and 285 Ontario Street, the buildings and structures, no formal complaint record exists in regards to deterioration of the building structure.
But you received 4 recently?
Sorry, speak
Tom,
to me, please.
Did you receive 4 complaints within this last 3 months?
Can the city comment?
Yeah, because you said there was 2 and 2.
Can the
Was that
city
25th?
comment on the circumstances that led to these orders?
I can, Mr. Chair. So when we receive a complaint, we follow up on that complaint.
Okay.
A call for service is a call for service, and we have a duty to respond, and we do. Whether there's a violation or not, we attend.
Right, I know, I realize that. Yeah.
And we cause an inspector or an officer to attend and follow up.
No, were those written orders or were they verbal orders?
Please speak through me.
Oh, I'm sorry,
Yeah.
Tom.
So
Sorry.
from what I heard is that
Yeah.
there have been no prior history of complaints, and the city will action upon all complaints. Is that correct?
Mr. Chair, that is correct. We action out all complaints received.
Yeah, and I realize there's been several organizations, or there's one big organization that wants this property rectified anyway. Anyway, any questions towards me?
Okay, so having said that, are there any questions of the presenter by the committee? Any further comments or questions by the city?
No, Mr. Chair.
Okay,
None?
okay, and I want to thank you
All right, thank
for
you.
looking after this and hope something gets done.
Okay. Is there anyone else from the gallery that would like to speak? We'll start with in the back row there. Yourself, ma'am? Yes, please. Yes. Good evening. Please state your name and address for the record.
My name is Irene Lowell. I'm a resident of the city of St. Catharines.
Madam Secretary, do we need to get the full address for the record? Or
will ask everybody to provide their full address and send it to me if they want to copy the decision.
All right, so
You can email me.
please state your name and full address for the record.
My name is Irene Lowell, and I am a resident of St. Catharines and a former employee of General Motors.
All right. Secretary Treasurer, do we need a specific address to proceed with presentation?
Do you need my home address?
You
No.
can provide it to me or they can provide it to Rosa over here, the resident of St. Catharines.
Okay,
If you're-
thank you.
if you're worried
Okay.
about that, yeah.
All right, thank you for the clarification. Please raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Thank you. I have serious concerns as a former employee of that plant in particular. There are areas of the plant that have buried tanks that were buried 12 feet under the floor that had carcinogens in them. They had coolant in them. I was there when they were covering the pipes because of the asbestos. Every pipe in that plant was covered so the asbestos wouldn't come down. However, up until that point, and that was in the late 90s, there was nothing there to protect the workers from the asbestos that was on those pipes. The other thing I would like to mention too is I worked in an area where we had coolants of all sorts that were so carcinogenic they wouldn't even put them on the labels of the tanks, the drums. Those drums are still there. Still there. Not marked, unfortunately. So to the people in that area, that's the deepest concern. Not only with the asbestos that's on the ground now that those pipes have broken apart, that covering has come off the pipes. And this is what I want this committee to realize and understand. People are dying because of that. Over the last, in 2010, when they closed that place down, if the research was done, and I've lost a lot of friends that worked in my plant. The first place I worked when I went there was called the carrier line. I had our health and safety guy come by me and say to me, Irene, this is Cancer Alley. Get out of here. And that was right across from Hague Street, right across from the Hague Bowl. So my concerns are really deep. We, at one time, had all of us in 4 departments had to go to Hamilton to be tested, to have our lungs tested, to do breathing exams, to see how we're breathing. And that was because we had 4 people in the plant that couldn't breathe. They were walking in every day with respirators on them because of the mist and the coolant that was in the air. And so I just want you to understand all that. And I have a suggestion for you men. Don't go on that
Please
site
speak, ma'am, please
without.
speak. Ma'am, please speak through me.
I'm sorry, Chair. I'm sorry, Mr. Chair. Don't go on that site without protective equipment, full protective equipment. And I have a question for you, sir. You said you represent the lender, not the developers. Is that correct?
Sorry.
I'm sorry, through the chair. I'm
Please
sorry.
direct questions through me, and understanding the nature
should
of
know
this
this 'cause I sat on a
application, please
board.
remember, we're going to treat people with respect.
Through you, Mr. Chair, I have a question. Sir, are you here for the lender or are you here for the developers?
So the question for
So
the
that's the
appellant
question
is,
for the gentleman,
and I
through you,
believe the answer stated earlier was for the lender. Is that correct?
the lenders. So I have to question the lenders. The lenders of this property. I question that. As someone who sat on a board of a credit union for 13 years, I know how that works. I'm very much aware of all that. So as a lender, giving money to these developers, did they do that without going through the plant? Did they do that without doing some research on the plant and what was there? Why would a lender give money to any developer, actually,
So if I may,
for that?
yeah, I
So,
appreciate.
sir, if
no,
you can answer me, please.
I appreciate the historical context and sharing your experience, but the questions have to relate to the property standards
And
order.
I am.
I don't
and
see
this-
the relevance.
And that relates because I was on that board. I know how it works. As a lender, and in the shape that that building was in, I'm trying to understand that. And my question also to the person, Mr.
I understand the question and your perspective. However, I don't see the relevance as it pertains to the order which has been issued to clean up the property, demolish and correct.
Okay, I'll buy that. I'll take that. Thank you. The other, I just up here because please deny this request. There's so much going on there. There's so much, and I understand very much how it's, we need time, but your time is up. It's been stagnant for 14 years. The demolitions were done, and yet they weren't paid. And so there's a civil lawsuit there. We all know about it. So I really just want to say to this committee, to you, sir, and to the staff behind me, thank you for what you're trying to do. I appreciate the whole city appreciates it.
I appreciate your passion. Thank you for sharing your experience in the historical context. Does any members of the committee have any questions or comments based on the presenter? Does the city have any questions or comments they'd like to ask of the presenter?
No, Mr. Chair.
Does the appellant have any questions or comments?
Thank you.
Thank you again.
Thank you.
Does anyone else in the gallery wish to speak? Sir in the back row there. Good evening. Please state your name and address for the record, please. Is the microphone up?
My name is Ed Smith, and I live at 140 Dalhousie Avenue.
Okay, please raise your right hand. Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
I do.
Okay, just as a reminder, this is a passionate subject, so please try and keep the presentation relevant to the orders in question. You may proceed.
Understood. All the protocols of this gathering are respected. I'm actually I had written out a delegation that I was going to read, but I have to say that most of it's been covered by previous speakers. So what I'm going to try and do is just kind of cut through some points that I think are germane and give you something to think about maybe that you haven't yet heard. Let me preamble it with saying that I recognize that the members of this committee are well aware of the purposes that you exist for. You're aware of the purpose and the importance of property standards. Some of the stuff, though, that I'm going to say, you might find like it's, I want to address people who may not understand some of the complexities. So bear with me if it seems that I'm telling you how to do your business, because that's not my intent. Property standards exist to protect public safety, preserve neighborhood quality of life, and ensure that property owners maintain their land and buildings in a manner that does not create hazards for the public or negatively impact the surrounding community. They reflect a simple principle: ownership bears responsibility. If a property fails and falls into a state that threatens safety or undermines the well-being of a neighborhood, residents are entitled to expect meaningful enforcement and corrective action. It's been more than 16 years that we've lived with the former GM site as not only a blight on our community, but a danger to us and to our children. Throughout that time, community members have consistently raised concerns. And I want to address the fact that no public, or I think the word was no official complaints were made. And I'm certainly not, I don't want to challenge that fact. What I want to say is that there were petitions and motions and movements by residents through the elected representatives, through this council. Petitions were presented with thousands of names on them. Now, I know that Mr. Chidoba and his office, they may not see them. I'm not saying there was any negligence in duty, but I'm saying the city was certainly aware. And so if there was a breakdown in the communications, that might be something internal for the city to look at. This property is not only unsightly and detrimental to neighborhood revitalization, but it's also a clear and present danger to public safety. These partially demolished buildings continue to attract urban explorers. You can go online right now and Google former GM site or Google whatever you want, and you will find urban explorer videos. 13 and 14-year-old kids are going in there and making their YouTube films of what they're doing in the site. Our community wishes to avoid a tragedy that would be similar to the one that occurred in Hamilton on April 4th. 2 months ago, a 19-year-old urban explorer in Hamilton fell to his death off a roof of a site that is pretty well a twin of the former GM site. It's a let's call it neglected former industrial site that is fenced off, and therefore the owners will say it's secure. Kids don't see security the way that we see security. A fence is nothing to them. For this reason, and many others, residents are justified in expecting a strong response to the long-standing conditions at the former GM site. It's been 16 years, as I said. What matters most now is decisive action by this committee. The compliance deadline, yeah, I get it, 3 weeks, like we all heard it, we all listened to it. It's the first time I realized it's standard operating procedures, and that's fine, I get that also. As long as the project or the demolition is moving forward, I believe residents will be, I don't want to say satisfied, but they'll be placated. They'll feel like at least something is happening. And one other thing I want to point out before I close is that, you know, we've heard about time being needed to get engineering studies and to prepare and to do this and do that. But the truth is that that property has been owned by one owner since 2014. It's that same owner that got it into the state that it's in now. I would assume that they did engineering studies when they started the demolition. I would assume, since 80% of the demolition has been done, that when they stopped the demolition in 2021, 2022, they were well aware of the site, if engineering studies, et cetera, are required. And then they chose to stop. Now they're saying they need to study the place before they can start, and that warrants delays. I don't think the community will buy that. If anybody should know that site, it is these property owners. They didn't just buy it this month. They bought it in 2014. They've had it for 12 years. They know the condition of the site. They know the engineering status of the site. They just had a report delivered to council, I'm going to say 6 to 8 weeks ago, on the condition of the catwalk, the catwalk that bridges Ontario Street, which coincidentally they said was strong, safe, and secure. And we heard in these council chambers, we heard senior staff affirming that. And then 4 to 5 weeks later, we see that a property inspection was done that completely contradicts what was said in this council chamber that night. Public trust is lost on this place, and what needs to happen is just positive action. We need to get things moving. Thank you.
Thank you. You made a point. You made a point earlier about enforcement, which I think is important to address publicly, which I believe you were speaking more towards proactive or active enforcement as opposed to reactive. I just wanted to see if the city could comment on the process for property standards, the mechanism for property standards enforcement and site visits and complaints.
Yes, Mr. Chair, I can. With respect to response.
Sorry, can you turn your microphone off?
Thank you, Mr. Chair. So with respect to property standards, we respond to public complaints. When they're filed with us, these are calls for service. We're provided with the information and we respond accordingly. We do not conduct proactive investigations for property standards.
Thank you. Do any members of the committee have anything they'd like to ask or comment on the presenter?
Through you, can we just confirm that this phone is not recorded, or recording, because we've already discussed that. This phone is propped up on the gallery?
Yeah, that's my phone, and it is recording.
Okay, we've had this conversation
Yes, it's
earlier.
been identified in the beginning of the hearing.
A public hearing?
It's being streamed on YouTube. You can grab it there.
So yes, you're correct, it's being streamed on YouTube, so I can also record this. I'm willing to
All you.
Can the Secretary Treasurer comment on the Statutory Procedures Act and the approved rules of procedure with respect to recordings of hearings?
So under Section 29 of the Statutory Powers of Procedure Act, and no recording is to be of any hearing, is to occur.
be stopping the YouTube live stream?
That's not recording it, that's part of the process. Private, without control of what you're recording people from the back.
No,
I could ask.
can supersede the charter.
The stuff,
It's a charter matter.
okay, so,
So please speak through me as the chair.
and we can ask the, we can.
I don't believe that any
So I'm not a expert in municipal. So we have a approved rules of procedure. So I'll pause the hearing. Do we have anyone from the city that can comment on that? Can you please come up to the podium or speak?
Thank you. Through you, Mr. Chair, my name is Sean Dorchani. I'm the Director of Legal and Clerk Services. I'm the city solicitor. And Ms. Hill does have a point. Going back to the Statutory Powers of Procedures Act, it does say that there are strict rules, but it also say that a tribunal or a committee can allow it should the chair decide that it's appropriate and there's no objection from the parties. And back to Ms. Hill's point, it is being streamed on YouTube. So at the end of the day, it is my respectful submission to you that is the same results. So essentially, if you deny an individual to record the proceeding and in the same way they can go into YouTube and grab it, that's essentially the same thing. So from a legal perspective, I would respectfully submit that it could be allowed.
I will accept that. However, I will say that we clearly identified that there's to be no recordings. That should have been identified before we proceeded with the hearing. So I would agree with you. However, in the interest of respect of the process, it would have been more respectful for the process to identify that and have this discussion prior to the beginning of the hearing, rather than have it pointed out halfway through. Yeah. Respectfully, for the charter challenge, and we have city legal staff here to comment, I think it would have been more appropriate and respectful to address that. Fair enough. There's no need for a stand-up. I'm just saying it would have been more respectful for this committee in the hearing to step up and ask that. Thank you. So with that, are we comfortable to proceed then? Sorry, I'm not, sorry, we are going to proceed.
I just want to comment that when they introduced YouTube, the three of us on the committee were really upset because we didn't want to listen.
If you're going to speak, please come up to the podium and you can remain, well, let's cover off that process first. Is there any questions?
Yeah, it was just a comment. You mentioned urban explorers, and I believe, through the chair, in the report, I think it says that it's in the complaint that there was a YouTube video of an urban explorer. Can you confirm
Right.
that?
So if there's going to be further discussion, we'll just proceed with the comment and then we'll circle back to it.
Okay.
So please step forward if you have something to say. So again, please state your name and address for the record.
Phil Baranowski at 18 Kilkenny Drive in St. Catharines, and it's just like the beer, Kilkenny beer.
One second. Do we need to reaffirm the oath?
No.
Mr. Baranowski would still be under oath.
Okay, thank you. You may proceed.
Okay. I just want to proceed is that when this is before your times, okay, and I was on this committee for 19 years, okay, and was always in here, and we had the odd person that came, and we weren't worried about it. But when they introduced that to YouTube, okay, our committee members were really upset because we felt that we were in danger because anybody could see that and not be involved, and we were worried that it affected us personally. So I just want to say, I am not in favor of this YouTube. If somebody wants to do it, but if you want to come to the meeting, you come. And if you want to take a recording of it, you probably have an interest of what's going on. But really, having your picture and your and you vote on something, because in the YouTube, the decision was public.
With respect, what we're talking about is a charter, right? And so the city legal staff has advised that there may be a legitimate claim here that supersedes the Municipal Powers and Procedures Act. So feelings do not supersede statutory rights. So if you have nothing else to add, I'd like to proceed.
No, I just want to say the history of what's going on.
Is not,
and
excuse me.
Technology has changed.
Excuse me. The history in this case is not relevant. I'd like to proceed with the hearing.
I definitely.
Thank you.
Okay, thank you.
So given the city's advice, I'm comfortable with proceeding. Just for the record, I think we could have addressed this more respectfully. Is there any questions of the committee of the presenter?
Just the one about confirming the urban explorer thing for the.
So the question through me to the city is the Urban Explorer YouTube?
Yes, I believe I read that in our package, that's where the complaint came from.
Yes, so the question is that the same video that was in the complaint package or in the hearing package?
Just confirming that way too close. Just confirming that the complaint came from someone seeing an urban explorer.
Okay, so the question to the city is, did the complaint that preceded these orders come from that video being provided?
Through you, Mr. Chair, to the committee member. So the information that we received, the complaint, did also include a link to a YouTube video showing a building in disrepair, and that building being the one that's being discussed today as well. That was included as part of that information.
Thank you. Does that answer your question? Brianna, that answers your question? All right. Any further questions of the committee of the presenter? Any further questions or comments of the city to the presenter?
No, Mr. Chair.
Any further questions or comments of the appellant? Okay, you may go back to the gallery. Is there anyone else in the gallery that wishes to speak on this matter? I don't know which one was first. Does it matter? All right, sir, you can proceed. Please state your name and address for the record.
My name is Gary Oblinski. My mailing address is Box 395 in Thorold, Ontario, L2V4J6.
Okay, thank you, sir. Will you please raise your right hand so I can swear you in? Do you affirm that the testimony you're about to give in this arbitration is the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
One thing, I have a notice over here. Could I have that submitted for the record?
Secretary Treasurer, is that something that could be submitted and circulated to the committee?
We can make copies of that.
Okay, I'm going to read it first because it's
Okay.
very pertinent. Important information for residents living near the GM site. Recent lab reports detected dangerous levels of asbestos in the soil at the GM site at higher than safe limits. Just because we cannot see asbestos does not mean the soil is not contaminated. Yes, you should be concerned. Asbestos fibers can be very small, between 50 to 200 times thinner than the human hair and visible to the naked eye. Asbestos is a risk to health when fibers become airborne and can be inhaled. Exposure can cause mesothelioma, asbestosis, and lung cancer. Symptoms may not arise for many years after exposure. Finding asbestos in the soil at the GM site is not surprising. Asbestos was used in manufacture and assembly throughout the GM site. Asbestos linings were attached to brake shoes. Asbestos wallboard was used extensively as a fire break in the walls and roofs of all the buildings. Asbestos labels can be seen on remaining insulation wrapping the steam pipe in the plant. Rubble piles left on the site from demolition likely contain asbestos. Residents should be vigilant. Although the level of risk associated with the newly discovered asbestos has yet to be determined, its presence in soil raises serious concerns. During hot, dry weather, dust laden with asbestos can be carried kilometers away by the wind. Any demolition, excavation, activities have the potential to release asbestos fibers if stringent migration measures are not employed. Why are we talking about asbestos now? 6 years ago, the coalition brought this issue up in a letter to former Mayor Senzik, council including Mass Cisco, as St. Patrick's Ward councillor at the time. Senzik said the city was assured by the Ministry of the Environment that licensed contractors undertook an asbestos removal program prior to any demolition of buildings at the former General Motors site in St. Catharines, and the ministry officials did not find any evidence of obvious asbestos sources. I don't see how that's possible. The condition demanded soil samples be taken to properly test for the presence of asbestos on the property, and any asbestos remaining at the Ontario Street site can be fully and safely removed without delay. No response was received. Recent confirmation of asbestos in the soil should serve as a call to action. The presence of a known carcinogen can easily become airborne on the site surrounded by residential neighborhoods. Demands a serious, transparent, and science-based response. The decisions made in the incoming months will determine whether this long-standing problem is finally addressed or simply passed on to future generations. Asbestos is a serious health hazard, and necessary steps must be taken now. Engage an independent expert. An asbestos detection, monitoring, and remediation strategy must be developed and overseen by an independent expert with demonstrated qualifications, experience, and expertise in asbestos decontamination and environmental assessment and risk management. To ensure public confidence, the expert must report regularly and directly to the community. All testing results, monitoring data, etc., and risk assessments and remediation plans should remain public and in full consultation with citizens. And independent assessment is essential to given the erosion of public trust resulting from years of inaction. Unanswered questions and conflicting assurances from the city, the province of Ontario, and the property owner. The community deserves objective oversight that is accountable to the public and guided solely by the protection of human health and environmental safety. Identify both the location and concentration of asbestos in the soil. Asbestos in soil is not typically distributed. As such, sampling strategies will need to be customized based on the site history and understanding of past use. Remove the asbestos-contaminated soil and dispose of it in an approved landfill. A licensed asbestos removalist must be trained in how to remove asbestos safely. This requires inspection by certified professionals, strict contamination and disposal in accordance with local environmental regulations. Why citizens' actions are so important now. With another municipal election approaching in October, residents have an opportunity to make expectations clear and hold effective elected officials and those seeking office accountable for what will happen next. I'm going to leave the rest because but I have concerns about asbestos. I'm familiar with asbestos, whether it be friable, non-friable. I have lung problems that may be due to asbestos exposure. I don't know. However, I know that it's a difficult remediation problem. I was employed by General Motors, and I was at the site on Glendale Avenue and the demolition of the foundry. I'm very familiar how work was conducted within the plant and how things were removed very quickly and efficiently by huge machines that don't take consideration of small particles of asbestos. That's number one. Number two, General Motors had asbestos in that site. I worked on heating ovens, etc., that were laden with asbestos. They took remediation by hiring a very, very specialized contractor, and they housed that furnace in an airtight, positive air enclosure. I don't think you're going to get this site to be doing that. I have other things I could say, but I think I've given enough of your time, and thank you very much for listening to my discussion.
Thank you, sir. Is there any members of the committee that have any questions or comments of the presenter? None. Does the city wish to provide any comment or questions of the presenter?
No, Mr. Chair, thank you.
Does the appellant have anything to add or ask? None. Thank you, sir.
I have one more question. I don't understand why the Ministry of the Environment is not being held accountable when they said there was no asbestos there.
Okay.
Thank you.
Thank you. So, just for clarity, specific to the particulars of the orders in question, the broader conversation of the asbestos, I don't necessarily think is relevant, but I allowed the discussion because I do think it is relevant for the broader public concern for the state of the site and the demolition, given its historical context. So if there's anybody else in the gallery that has anything that they wish to add or speak to that's new or different, please come up.
Hi.
Please please state your name and your address for the record, please?
Emily Spanton, I live on Bayview Drive. I'll give you the actual number. I just have something
Sorry,
quick.
please raise your right hand.
Oh, yes.
So I can swear you in. Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You can proceed.
I'm just going to quickly read something off of the city's own website that I feel is relevant, and it's my only comment. I feel we've been at this for a while, so I just want to point out that according to the city's own website, 2022, legal action was successful against this property owner, and those were charges under Building Code Act as well as the city's waste bylaw. They've also previously been fined under fire bylaws. So I just feel like that was 4 years ago, and what's been done in the past 4 years. So we're coming back with more violations. Nothing's really been done. I don't see how pushing everything out is helping. I don't see any work has been done since these charges. They pled guilty to multiple charges within a 6-month period. And literally that was 4 years ago. So to say that they need more reports, what have you been doing in the past 4 years? You were aware there was a problem. You pled guilty in criminal court over this very property, same owners, and we're still sitting here seeing the same issues. So I just feel it's been pushed further along, and I understand these might be under different bylaws in different parts of the city, but the point is the property has been an issue for a long time, and the owners have been approached under various bylaws and various acts, and we seem to still be in the same place where we're not seeing the cleanup that's been needed for a long time. And that's it.
Thank you. Do any members of the committee have anything they'd like to ask the presenter? Does the city have anything they'd like to ask?
No, Mr. Chair, thank you.
And the appellant? Thank you.
Thank you.
Does anyone else in the gallery or the members of the public wish to come up and speak? Okay. Are there any members of the public registered to speak online?
There are no members of the public registered online.
Thank you. So at this point, we're at the point of closing submissions, so I will turn it over to the city's case presenter to proceed.
Thank you, Mr. Chair. My position is fairly clear. We look to have the order confirmed as written, modified with an extension of time to comply of 120 days to comply with the order as written. Outside of that, from what we've observed, the buildings have been stripped of pretty much anything valuable, making these buildings likely unsalvageable. However, should that be the case, once again, looking to confirm the order for 282 Ontario Street, 2026-106-611 MB, issued May 22nd, 2026, confirmed as written, 120 days to comply. 285 Ontario Street, Order 2026-106-552, MB, issued May 22nd, 2026, confirmed as written, 120 days to comply. Thank you.
Thank you. Prior to turning it over to the appellant, I have some comments and questions that I hope you could address in your closing submissions. Through the presentations and what we've seen, there is through graffiti and other indications that there is indications of site access, whether it's historical or not, dangerous pits and openings and risk of falling debris, countless broken windows, boarding that does not comply with bylaw standards, unsecured openings and access, a pattern of neglect shown by the history of property standards orders and lawsuits, and most concerning, social media videos circulating showing youth and other urban explorers on the site, despite the security that's been mentioned. Engineering reports are ongoing and can be used to address the relevant items of contravention as applicable. The statutory requirement to comply has been addressed through the Ontario Building Code. That's not a city procedure. The city has indicated that they do not actively prosecute if they see ongoing process. And many points on the order can be actioned immediately. So my question that I'm hoping you can address in the closing submissions is, what is the benefit of the 120-day extension if the city is not going to actively prosecute? And is it really feasible that a complete cleanup and demolition and compliance with all orders of the order, all points of the order can be complied with within 120 days?
Thank you, Mr. Chair. Through your prepared question there, I can, just in terms of the closing submissions, so I act for the lender. I don't act, so I want to make that clear. That may not have been clear as it maybe should have. These orders deal with the existing buildings on either property. I respect the comments from the neighbors as it relates, or the public as it relates to issues with the historical nature of the property, but these orders specifically are limited to those two existing buildings. So I would suggest that the comments from the public actually support exactly what we're saying, is that this is a complicated property, which is why we ask for a deferral, because this needs to be assessed. You have issues of asbestos that can't be remedied or can't be addressed within 21 days. That has been the time frame offered by this, or ordered by the city within their order. There's issues with obtaining permits, or obtaining whether to demolish or to repair. All of this supports the notion that this is a complicated property that needs to be properly and technically examined, and which is why it needs an engineering report to review what the actual requirements are. As I said in my submissions, Mr. Chair, there's diligence in the sense of securing the property in the form of fencing and regular patrols on a daily occasion, several patrols on a daily occasion. But people who are trespassers may be finding their way in, but obviously that's an illegal act, and but effort is being made to prevent that. Mr. Chair, your comment about ease of compliance with the order, I don't know that I agree with that position, but as I said, that's something that needs to be assessed in order to properly respond to that. Your issue about enforcement of the order, well, in theory, the city could enforce the orders right now and charge our client, or charge the owners of the property with those orders. So what is said today could change tomorrow. I'm not suggesting that it will, but the extension of the time, if that is the will of this committee, as I said, our initial position is that we're not prepared to answer substantively to the orders because we don't have the requisite report that's needed to do that. But if it is the will of this committee to provide an extension, that allows us to do review the property from a technical perspective, as complicated as the public even agrees with, in order to assess the nature of the property vis-a-vis the order, and address the order and have time. That is a reasonable request, and that is often what is afforded to anyone else who does this. But in this case, you had an order issued on May 22nd, and here we are before this committee approximately a month later addressing it. You heard the first matter that was, the order was issued in March, and then the hearing is in June. But and that was just a very relatively minor matter. I think, I'm not going to bring the evidence in on that, but that was a very minor matter. And here we are here a month into it, and we are required to meet the 21-day deadline that's already passed. So with respect, Mr. Chair, I think reasonableness needs to come into play here, not doing this all in a whim. And as I said, if it is the will of this committee to grant an extension, we've suggested that 120 days from today's date. I'm hopeful that we will be able to meet that deadline, but because we don't know the nature of the property, leaves us with a problem.
Thank you. So at this point, the committee can deliberate, and if anybody would like to propose a motion, feel free to do so. We can either do the motions individually for each order or combined.
I'll start a motion.
We have a motion?
I'll start the motion. The items for property standards I move that items on property standards orders number 26106611MB for 282 Ontario Street in St. Catharines, as well as the orders for 285 Ontario Street, and I just turned away from the numbers. Yeah, oh, there it is, thank you. 26105552MB for 285 Ontario Street. I believe, so I move for the orders to be confirmed as is, and that the date of the repairs are to be affected, to be extended to October 23rd, 2026.
So to clarify, the motion on the table is a combined motion for both orders, 1 to 3 items on the first order for 282 and the 7 items on 285, and the motion is to confirm the order as written with an extension of compliance for 120 days.
Confirmed.
So with that, all those in favor of the motion? All those against? Secretary Treasurer, will you please read the decision?
I didn't see that. So Brianna was for?
Yes.
Okay. So we, the undersigned, duly appointed members of the Property Standards Committee of the Corporation of the City of St. Catharines, constituting a majority of the said committee, sitting on the 25th day of June, 2026, to hear an appeal from Order 26106611 MB of the Property Standards Officer dated the 22nd day of May, 2026, and with, just bear with me here, and for Order 26106552 MB, make the following decision, that in the opinion of the committee, the order meets the general intent and purpose of the Property Standards Bylaw and the city's official plan, and direct that the 2 orders be confirmed as written and extend for compliance to October 23, 2026. In accordance with the Building Code Act of the municipality in which the property is situated, or any owner or occupant or person affected by the decision of the Property Standards Committee may appeal to the Superior Court of Justice by notifying the clerk of the municipality in writing and by applying to the court within 14 days after a copy of the decision is sent.
Thank you. This concludes our scheduled hearings for today. Thank you to all the participants that participated and attended today's hearing. The appellant, you're now able to leave as we continue with our agenda. If I can just ask for a little bit of quiet, if people are going to leave, we do have a couple items to consider. Secretary Treasurer, do we have any new business to discuss?
We do not.
Is there a date of a next hearing or potential next hearing available?
At this time, there is no future dates.
With that, then, do I have a motion to adjourn the meeting? Okay.
Pick one.
Meeting is, everybody, meeting is
Everybody?
adjourned.
Okay.